Hi, this is Dave Davidson. Welcome to the webinar. We'll give a couple minutes to see if anybody else joins in, but hopefully you can hear me. Okay, let's go ahead and get started. My name is Dave Davidson. I'm an attorney with the Florida Healthcare Law Firm, and within the last 2 months, I have expanded my practice kind of for COVID-19 law. And as you all probably know, a lot of that area of law involves human resources, and a lot of it, I think, is falling on human resource professionals and those with human resource responsibilities in the practices. So I know what you've been going through the last couple months, and I'm here to tell you that a lot of the COVID-19 reawakening will also fall on you. So it's probably a good idea to talk about a little bit where we are right now and what to expect when you come out. The first thing to remember is that the old liabilities are still there. There are some rumblings about business protection and malpractice revisions to the standard of care, but there's nothing concrete in Florida or federally yet. I saw a report yesterday that the Senate is going to propose a new aid package that will indeed include protections for businesses in regard to litigation that could arise out of COVID-19, but I've not seen a summary of what those involve yet. I imagine they would be protected. I'm not 100% a similar suits from employees, but we will keep an eye on that, and as things occur, we will post them online so you are aware of them. But nothing has changed, in your day-to-day concerns about liability in your job. But as you know, there are some new liabilities too. You still have issues with terminations, furloughs, layoffs, discrimination, and political issues, and all of that. And COVID-19 just adds another wrinkle to those problems. Not only in employees' concerns about coming to work, but in how they deal with your patients and the folks that come into your practice. There's a lot to it, and there's really not a clear answer yet because this is uncharted territory. However, OSHA has put up some special guidance on their website, and I think everybody is aware of the CDC guidance, and I think the best way to protect your practice from issues with employees is to follow the guidance from those federal agencies. You are required to act reasonably, you are required to have a reasonably safe environment, and if you can demonstrate compliance with the requirements of OSHA and CDC, you should be able to defend an action by an employee saying you didn't act reasonably and they were injured. But always be aware of what, I think by now everyone knows what the symptoms of COVID-19 are, but within your organization, you should know the symptoms, should stop the spread, you should have a plan of action should anyone test positive, and you should be ready to notify your employees of any potential exposures they have, recognizing that HIPAA and the ADA are going to mandate confidentiality. One of the biggest HR issues that I'm sure you've had to deal with are the funds that have flowed from the federal government to your practice in one way or another. The big three are the Family First Act, which is the act that created that paid sick leave and paid FMLA connected to COVID-19 issues. The Paycheck Protection Program, which I imagine a lot of you are participating in, and the CARES Act relief funds, which is the money that was suddenly deposited, I think, April. All of these are tied to HR to one extent or another, and there are some other funds out there, the economic injury loans and things like that. What I will talk about today will, for the most part, apply to those loans either, but these are the big three. Use of the funds is pretty well been documented. Families First Act, that the paid sick leave and the paid FMLA, the employees must meet the criteria for that in order for your practice to get the dollar-for-dollar payroll tax credit. All of these, and not just the leave opportunities, but all of these are really great programs. I think they've been beneficial. They have helped a lot of my clients keep their doors open, or at the very least, if they've closed their doors, they've been able to continue to pay their employees. So I think the motivation behind these is great, and I think it's been very beneficial for the most part to all of my clients. But as with any time the government gives you money, there's strings attached, so compliance will rear its ugly head. So it is important that you use the pandemic funds appropriately. Like I said, the sick leave and the paid FMLA, those are pretty clear. They're 6 criteria or 6 different buckets an employee could fit within in order to qualify for those. The Paycheck Protection Program, again, the bulk of that has to be used for payroll costs. There are some other permitted uses, some of which will still allow for forgiveness, and some of them will not be subject to forgiveness of the loan. And then the CARES Act Relief Fund, the law said that those funds were deposited by Medicare for preparation for COVID-19 and in response to COVID-19 and lost revenue. Like I said, whenever the government gives you money, there's going to be strings attached. With the Families First Act, the benefit is that you get the dollar-for-dollar payroll tax credit for the monies paid for employees or paid to employees taking advantage of those leaves. But note that tax credit is deemed to be receipt of a federal fund. So even though it's a credit and it's money you don't have to pay, it's money you would otherwise have to pay. So the government sees that as a benefit, or actually federal funds being paid to you. Paycheck Protection Program, like I said, is subject to forgiveness so long as at least 75% of the loan is used to cover payroll costs, which is obviously payroll, but can also include employee benefits and things like that. The remaining 25% to remain forgivable can be used for rent, mortgage, utilities, and things like that. My recommendation, though, is always use as much, if not 100%, as close to 100% as possible for payroll costs, just so you don't run into problems later with the government saying, no, it's not forgivable. Note that you also have to maintain your payroll costs and your FTE count fairly level through the 8-week period. There's a somewhat convoluted formula for determining that. That's too close to math for me to take the time today to explain it. But you can't lay off a bunch of people and then increase the salaries for the remaining 10% there and still have the loan forgiven. Both your payroll costs and your FTE count have to remain fairly stable. If you're not stable, you have until June 30th to rectify that. So note that deadline for the PPP calculations. And as an aside here, we all know the government has given out a bunch of money within the last 2 months to businesses, to individuals with the stimulus checks and things like that. And now I think as the dust is starting to settle, they are starting to feel like maybe we shouldn't have given out all that money. So 10 days ago, 2 Sundays ago, the government sent out a couple extra guidelines for consideration with the PPP loans, and that's asking people who received it to reconsider whether they really needed it. Look to see whether you had a line of credit, whether your payroll expenses really were going to be what you said they were going to be, and if you don't think now that it was necessary, please go ahead and send the money back. Interesting development. There's nothing in their guidance that makes it a mandate that you return it, but it just kind of, I think, is a foretaste of the way the government's perspective on these funds may change as we get through the pandemic crisis. The CARES Act relief funds, you can get liability from that as well. Again, like I said, this is money you didn't ask for, but the government gave you if you billed for Medicare last year. So they basically, and the uses are very vague. It's preparation in response to COVID-19 and lost revenue because of COVID-19. And there's not a whole lot of guidance otherwise on how to use it. So the government basically said, here's a bunch of money you didn't ask for, use it in these vague ways, but don't forget that we will penalize you if you don't use it right. So I think it's still up in the air on what's going to happen with those funds and any liability that could arise from them. It's kind of like saying, here's a bunch of money, I'm going to pay you a bunch of money to walk down the street. And then when you walk down the street, they say, well, we need that money back because we wanted you to walk sideways down the street and you didn't walk sideways. So it's a little bit vague. We'll see how liability comes, but be aware that that's out there. There are some significant penalties that can come from misuse of the funds. You could lose the forgiveness for the PPP loans. And yes, the interest rate is 1%, but they have to be paid back in 2 years. So it is a short amount of time that the money would have to be repaid if it's not forgiven. And it's not all or nothing. A portion of it could be forgiven and a portion of it could be payable. So it's important to use it in the ways that would allow for forgiveness. Similarly, you have to repay the amounts received under the other programs as well, including the payroll tax credits if the leave time from Families First Act was misused. Most significantly, though, the government has been clear that the False Claims Act still applies to all of these funds that were paid. And that means the government can assess treble damages, meaning 3 times the amount of money that you were paid. So if you received $100,000 in PPP funds and you misused them, you used them to build a new wing on your building or something like that, the government could ask for $300,000 in return. And I know some of these loans were significantly higher than that, so the damages under the False Claims Act could be similarly outrageous when you triple the amounts paid. There could also be civil money penalties, which would range up to $11,000 per claim. So let's say you paid or you asked for the payroll tax credit for employees who did not fit the criteria of the Families First Act, FMLA, for example. For each dollar or each pay period or each employee that was involved there, the government could assess you an $11,000 penalty for each one of those. There could also be additional fines imposed, and if the use was fraudulent, in other words, if you used the PPP funds for something not permitted under the program, but yet you reported that you did and you intentionally falsified it and committed fraud, the government could even consider criminal prosecution as well as civil litigation. So the use of these funds are very significant. And like I said, we're already seeing the government not have second thoughts, but to start tightening the compliance screws. So that's why it's important that you prove the propriety of the use of the funds. In other words, you use them the way they're supposed to be used. Because the government reports and what you'll have to send to the government will require significant detail on how every dollar was spent. And I think the detail will be even greater if you received more than $150,000 in funds combined. That's with Families First, that's with PPP, and with the relief funds from Medicare. So if you receive more than $150,000, your reporting is going to be significant. Now, some of those funds can be used outside of the HR arena, but I know a lot of you also wear multiple hats. So it will be important that you are able to document the use of all of those funds. And again, including the criteria for the paid FMLA and paid sick leave from the Families First Act. So even though you didn't get that money in your pocket, always remember that that is still out there. Because like I said, the government's attitude is changing. They're going to suddenly see you as ungrateful children who received all this money and didn't use it the way you were supposed to. So be careful and make sure that your contemporaneous record keeping is very detailed, because it will be essential in avoiding liability. So now let's talk about the true focus of your job in human resources and cover some issues with employees. There are several significant issues that are going to arise related to COVID-19, in addition to, like I said, all the other liabilities you spend your days worrying about. You have employees coming back to work. You have employees, either from a leave or from a furlough or from paid time off or whatever, multiple reasons you have employees coming back to work. You also have a need for employees coming back to work. As Florida gets back to work and elective procedures are now permitted, and as all of these things that have been shut down start moving back, you're going to have needs. They may not be the same needs you had in January, but you're going to need employees back if you've sent folks home. So they'll be coming back for multiple reasons. You have furloughed employees and some of the issues that arise with them. You have laid off employees that, whose relationship with your practice was completely severed. And now may come back to work. And then you have employment contracts out there that obligate you as an employer to behave in a certain way and provide certain benefits and expect certain things from employees. So that's, to me, that's been something of a forgotten issue out there. I have some clients that have done an excellent job in complying with their employment agreements and amending them with their employees when they have to, and I have others that have completely disregarded them, which could come back to bite them in the future. So let's talk a little bit about coming back to work. Who comes back and who doesn't come back? Well, who do you bring back? Base that on need. If you've sent employees home and you don't have a need to bring them back yet, even though business may be picking up, you're not required to bring them back. Even though you may have sent a bunch of people home on the same day, you can bring them back on a sliding scale. But base it on need rather than just the fact that the state is opening back up and the governor is lifting a lot of restrictions, and in theory everybody could come back. Be judicious in bringing folks back. And my second point on who comes back, bring back the best. So if you have a need, who is the best employee to bring back to fit that need? You may have had two people filling a role in the past, and now you only need one. So bring back the best one of those two employees. You don't have to bring them back based on seniority. You don't have to bring them back because they're the loudest or the squeakiest wheel, or anything like that. Just bring back the best employee that meets your need. And that kind of dovetails into who doesn't come back. I have counseled many clients that from a very high level, this gives you an opportunity to upgrade your workforce. It's unfortunate, but there are a lot of good people out on the street, and it may be beneficial, again, to judiciously determine if there are marginal employees that should not be brought back to work. And even though they may have been furloughed and temporarily sent home, you can consider whether a layoff of those individuals is appropriate. As you know, from working in HR, this can be a minefield. So be very, very careful in how you do this. Obviously, you can't discriminate against anyone. You can't say, well, I'm going to bring this person back because they're a woman, or I'm going to not bring this person back because they're a woman. You can't discriminate against people. You can't use that as a reason to not bring them back. Any of the discriminatory things, age, sex, race, religion, gender, all of the things protected by Florida law cannot be used to bring people back, or to not bring people back. So don't discriminate, but like I said, be judicious and use this opportunity to upgrade your workforce, because you can rid your practice of marginal employees, and this is a good opportunity to do that. I have counseled several clients as they have negotiated through this process, and I think they're all very comfortable with how they've handled it. So pay attention to who comes back, but also don't forget to pay attention to who does not come back. And talking a little bit about status of employees that were sent home, we start with the furloughed employees. These folks were sent home on what was planned to be a temporary basis, even though they are or were able to apply for unemployment benefits while they were out because of the change in their employment status. The idea behind a furlough is that it's temporary, and then these folks are going to be brought back at some point to work. With a furloughed employee, when they come back, they basically have the same seniority they had when they left. They have the same benefits and things like that. And hopefully it's a fairly seamless return to work, similar as, to being, coming back from any type of leave of absence. So hopefully the furloughed employees come back smoothly. It can be a little bit bumpier with laid off employees because with the layoff, the employment relationship, is actually severed. So furloughed employees still have their employee status. They're part of, at least to some extent, part of your workforce. They're just out on a leave, doing zero work for you. But laid off employees are no different than anybody else whose employment is terminated. So if you intend to bring back someone you laid off, you could face some issues because they will be treated as brand new. Now you may still be able to take some steps internally, the things you have complete control over, to restore their seniority and return them to the amount of paid time off they had or other benefits like that. But with benefits that were provided through third parties, you could have some issues. For example, a lot of times the health insurance plans that you provide your employees don't kick in for 30 days after a new hire starts work. With the laid off employees, that lag time may apply. You'd have to check with your health insurance carrier on that, but that's generally the rule with the laid off employee. So, but that is something you'd have to talk to the third parties about in any attempt to restore any seniority to someone who was laid off and now brought back. And again, employment contracts, be very careful with conflicting terms. If you have employees that have contracts, and most of the time it's the physicians or professionals in the organization, but you may have some physician extenders with contracts, you may have administrators with contracts. Those contracts don't go away because of the pandemic. So the terms of those contracts are always still going to apply. So you always have to have that in the back of your mind. Even if you have two people filling the same role, if you have two managers, for example, and one has a contract and one doesn't, you may have to treat them differently just because one has a contract and the other one does not. So be aware of those. There are some defenses available to contract compliance during COVID-19, but those are temporary for the most part. There's impossibility of performance that's available should you face litigation, and there's some other things to, the inability to meet the intent of the contract and things like that. But those would only apply during the pandemic. So now that the state is reopening, an employee with a contract that may have been suspended or not followed while everything was closed may suddenly now have an argument that they are back entitled to 100% of the benefits of their contract. So be careful with those terms. There are very few contracts, I think, that were written before February 2020 that included an excuse for noncompliance based on a pandemic. But I reckon that 100% of the employment contracts that are drafted after February 2020 include some kind of phrase like that to protect the employer, if there is a public health emergency. So be careful of your contracts. I think, and I don't, I know of some litigation that's out there already over employment contracts during the pandemic. And I suspect there may be a lot. I know there were a lot of unhappy physicians who had their contracts changed, that had their compensation unilaterally reduced. And so I think there may be some significant litigation on the horizon there. So to avoid that, make sure you follow your employment contracts as closely as possible. And when they are in place, those employees deserve not necessarily extra care, but extra attention to make sure you don't put yourself in a breach situation. Finally, there are a couple other miscellaneous points that I think are worth talking about that I have found in my last 2 months of practicing COVID-19 law. The first is I heard of a practice in Central Florida that furloughed all their employees, pretty much closed their doors. They maintained a skeleton staff for emergencies, but they also were going to bring everybody back. And obviously that's an excellent thing. From what I understand, they're not a client of mine, but from what I understand, they're a strong practice, and they're going to be able to rebound, and everybody's going to come back to work. But as a condition to coming back to work, they asked their employees to file or execute releases and sign releases saying that they released their employer for all liability in regards to COVID-19. That's probably a stretch. Those are probably not going to be enforceable. If they release things that have already released the employee of things, employer of things that have already happened in past, that they might be effective. They might say, we know we botched some things coming into the pandemic, but if you want to come back to work, we need you to release us from the mistakes we made. That's probably okay, but you can't sign a release for things that haven't happened yet and expect it to be enforceable. So I understand the thought process behind it and the protection that this practice was looking for, but I'm not sure they'll be enforceable or valid. And as an employee, it would raise some questions in my mind about coming back to work if I'm releasing you ahead of time. As an alternative to a release, though, I think consents can be useful. A consent signed when an employee or as your employees come back to work. It wouldn't be a bar to litigation. In other words, it wouldn't stop somebody from suing you, but it would be useful in litigation to have a consent. And really, it would be the ones I've seen are fashioned along the lines of an informed consent that you give your patients. Everybody is aware of the COVID-19 risk, but it basically says there's a risk of COVID-19. The nature of your practice will, probably does not mandate daily testing of employees or patients or other folks that may come to the hospital. But the practice has taken these steps, and I would recommend that they be in accordance with OSHA and CDC, to make sure that appropriate precautions are taken to protect the employees. And then you can have the employees sign that, and that they recognize that these are reasonable precautions, that they agree to abide by them all the time, because if your precautions require 100% use of a mask when an employee is in the office, and the employee takes it off, but they breach that protocol, and again, that would be a defense for you should they get sick later, but bring suit against you. So an informed consent to come back from work can work, and if you have a concern about things like that, it can be a useful tool. I've had a lot of questions about doctor's notes. A lot of employees have requested time off or the sick leave based on a physician's note. And honestly, I have seen some crazy notes. Almost like, a note when I was in second grade, the note I wrote to my teacher excusing me from school. Some of these notes that I think the employee just says, write this, the doctor writes it, and then gives it to the employee/patient, and they give it to their employer. Some of them have been just amazing. But it's still a doctor's note. It fits the criteria of the Family First Act, in that it's a recommendation for quarantine or what have you. And so it fits them under the opportunity to take that leave. If it's a doctor's note and it's a real doctor and it's a real note, I think you can abide by it safely. But one thing you should consider as the employees come back is whether you should have a doctor's note saying they can come back. I recommend it if at all possible, because I do think it protects you. I did have one client, and again, all my war stories are true, but I never use war stories from the areas in which I'm speaking. But I did have one client in a different part of the state who had an employee request Families First sick leave off because she was immunosuppressed, and she had a doctor's note saying that my patient so-and-so is immunosuppressed, and I'm recommending that she self-quarantine because of COVID-19 and the risks involved. And so they gave her the time off. She self-quarantined, and then when her paid time off ran out, she came back with another note from her doctor that basically said, this employee so-and-so is still immunosuppressed and she's still at high risk, but she can come back to work. And this particular client elected to not accept that because the way it was written, it seemed like it was transferring a lot of liability back to the practice that they really weren't comfortable accepting. So she's still on the payroll, but they've not returned her to work because of, the doctor's note itself said there's still a risk for her coming back. So I thought that was a little bit unusual. My guess is, as you are all dealing in HR, you've probably seen similar things. But I do recommend that if a doctor's note was used to excuse an employee from work, that they should have a doctor's note allowing them to come back. And that may be part of your day-to-day practice. Anyway, safety concerns, you're going to have employees who are afraid to come back. That's okay, but if they do choose to take that time off, that's either unpaid or using their own sick time or paid time off. And if you do have the OSHA level and CDC level precautions in place, any employee that does that does risk a termination or a permanent layoff. But I do suspect every practice will have a handful of those employees. There are workers' comp issues that could arise, which again is why the reasonable precautions need to be in place. Protecting the employees and from exposure and setting out the process to comply with in the event there is exposure. Malpractice and general liability issues, there is hope for relief in certain instances. Some states have changed the standard of care that must be proven if a patient elects to initiate a malpractice claim arising out of or during the COVID-19 pandemic. Nothing has happened in Florida along those lines yet. I know the FMA and some others are pushing for it. I'm not sure that will happen, but it will be. It is being considered, and on a national level, it's being considered as well for some protection. I also fielded some questions from clients about reductions in malpractice premiums from insurers, and I've not seen that happening anywhere. And I talked to a buddy of mine who sells malpractice insurance before the program today, and he's not seeing anybody reducing rates, but it seems like across the board, insurers are not terminating coverage for non-payment. They are extending payment terms, and they are, not charging interest and things like that for late payments. So the insurers are giving some relief to their insureds, but not relief to the extent that their rates are reduced. And I think part of that is nobody really knows what's going to come about as we get back to business in the state. You can do the elective procedures now and the non-emergent or non-urgent procedures, but nobody knows if that's going to result in a new wave of infections. And I think the insurers are worried that as these elective surgeries get done, if somebody is exposed to the virus, that could add additional liability rather than a reduction in liability, even though for a certain period of time your practice may have been completely closed. And finally, whistleblowers. The federal government was very clear that the whistleblower provisions of federal law still apply in all cases, and in fact do apply to all funds conveyed through the COVID-19 legislation, either the relief funds, the PPP funds, the Family First Act, time off, the economic injury loans. All of the loans have the whistleblower opportunities attached to them. Basically, that's a provision of the False Claims Act that allows an employee to report you to the government for misuse of funds. And again, as I mentioned earlier, could result in you having to pay back 3 times the amount you received, along with additional fines and penalties. The whistleblower provisions also allow that reporting employee to share in a portion of what the government gets back from you. I'm very cynical about this law, and I will save my editorial comments to a different program, but this still all boils down to documentation, to make sure that you are using the funds appropriately. They are going to the uses that they were earmarked for, and that you will report the use of those funds truthfully back to the government. But the whistleblower provisions keep the tattletale employees on the alert, And so you will also face that cry again as you start looking at your workforce. That's all I have for today. Thank you for joining me here. I think on the chat section of the GoToWebinar menu to the right of my screen, you have the opportunity to ask any questions. Feel free to do that. Or my email address is there on that last page, and I did upload the program onto the dashboard. So feel free to download it. Let me know if you have any questions. And if not, I don't see any questions typed in. So I hope you have a wonderful day. Stay healthy and enjoy the rest of your week.